Okay, yes, you are. I think we're ready. I'd like to call to order the Planning Commission meeting on June 14th, 2012 at 6 p.m. And I would like to start with a roll call, and I'll start on my right.
Ryan Coleman.
Mike Luxembourg.
Kathy Richardson.
Mahbubul Islam.
Jeff Wasserman.
And Mike Collins.
I'd like to note for the record that we actually do know how to go in order most of the time.
I wasn't listening. I thought you responded. I'm sorry. There you go.
And also Commissioner Lipinski is absent tonight. I'd like to first start with a change to the agenda. We are going to remove the approval of the minutes from May 17th from the agenda for tonight. We will actually have that on the agenda for our next meeting. And I'd like to request approval of the agenda with that change.
So moved?
Second.
All in favor?
Aye.
Thank you. So the next item is a review of our work program calendar.
Let me get us started, and then you can kind of jump on from there. As usual, on the city website and card copies over there, we have two calendars that we've been making for this process. One's our standard calendar, just showing that this is the only subject the commission is dealing with at present. And this is a more detailed calendar showing the specific topics and goals for each night during the environmentally critical areas review process. We're graying out the meetings that have been completed and still showing the meetings that are scheduled. We are right now showing some contingency dates in early August. I think the chair will talk a little bit more about that when I'm done. But that hasn't changed substantively in terms of the dates that we've shown. We've just been making progress through those. So, Madam Chair, do you want to take it from there?
Sure. Can we turn the projector on for everyone? Thank you. So I wanted to talk through kind of where we are today and where we're going in the next few weeks and months so that we all have a shared understanding and maybe have an opportunity to help modify things as we go forward to respond to events that are unforeseen. So first of all, I want to just remind everyone that we have a success statement that the Planning Commission has adopted, and we've got very clear, consistent direction from the City Council to be very thorough, to be inclusive and fair, and to have a well-documented not only process but outcome. We are on track based on our schedule, and I think that's great testimony to both the Commission, the staff, and the citizens that have been involved in this process. We currently have 39 amendment items or recommendations for amendments that we have already discussed to some degree. And we do anticipate some additional amendments or recommendations from tonight's topics and the public hearing. Several of these amendments do require more thorough analysis and discussion, I believe, and I think this belief is shared by many, before we actually make a formal decision around the changes to the code. So we want to make sure that we incorporate sufficient time for that before we go into our formal deliberation. And we would note that a public hearing and those deliberations have not yet started. So there's still quite a few unknowns ahead of us, even though we are on schedule today. So our strategy to kind of get through this analysis and discussion process is to actually have some discussions in July as a commission. The goals of those discussions are to achieve a deeper understanding of the issues. We've had quite a bit of thought and conversation, but I think many of the issues require, further discussion and a deeper understanding than what we have today. We want to understand how the various issues and decision-making elements interact before we make any formal decisions. And we want to make sure that we have an understanding of the potential impacts of any changes we might recommend. So what we are planning to do is conduct some risk analysis discussions in July. We will have documentation available to the Commission and the public in advance of these meetings, and we will be modifying and adding to that documentation throughout the course of these meetings. So really, this is to have some deep discussion about what are the options and alternatives that we have in front of us and what the implications are, and what can we or can we not do, what should we or should we not do, and what are the implications of those things. All of this information will be captured and available prior to the public hearing. I want to be really clear about that. So our process is to complete all of the analysis and discussion and have that published for the commission and the public prior to the public hearing. The public hearing will then take place. That's essentially the final opportunity for the public to comment on the information that we have available to us. At that point, the public comment will be closed and the commission will commence with our deliberation. So our point in doing this is to make sure that we're thoughtful and thorough, to make sure that we're transparent about what we're doing and what we're considering, and to make sure that everyone has ample opportunity to both comment on the materials that have been provided, but also to consider them. The risk analysis is a document that we plan to produce and make available to the commission for our decision-making, to the public to know what the input is to our decision-making, and ultimately to the council. As part of our packet to the council, we will provide them with kind of this documentation of our decision-making process and the inputs to that process.
Next slide.
So here are some things that risk analysis is intended to address. There are a number of aspects that we want to consider when assessing risk: environmental protection or outcome, property rights or benefits for owners and applicants, administrative issues and costs both for applicants as well as the city, and the technical feasibility of some of the alternatives that we might consider. And we'll look at all of those elements. We'll look at the aspects of, the likelihood. So, for example, the likelihood that something is technically feasible, and what the impact of a particular alternative might be, and try to come up with not only with some qualitative, likely qualitative, ideally quantitative, but likely qualitative assessment of the risk of any particular alternative. So, and we're kind of thinking some sort of rating system, high, medium, low. Not sure exactly what that's going to look like yet, but that'll come out of these discussions. Some alternatives may be high risk from a technical feasibility perspective, but low risk from an environmental or developer perspective, as an example. Those are the kinds of things we're trying to assess. So given that, our current calendar shows we're going to complete the initial presentation and recommendations for all of the known topics in June. That is what the current schedule says. That is what I fully expect we will accomplish that. In July, what this means is we need to have the risk assessment discussions, public hearing, and deliberations in July. And I think what we're all starting to consider is whether or not it's practical for us to expect to get through all of that in 1 month. So at the end of our first risk analysis discussion, which we plan to have on the July 12th meeting, we will actually assess where we are. We have 39 recommendations to get through. We will not assess the risk on all of them. We will actually focus on the things that we think are most critical or impactful. So really focus our discussion on the high priority items, or high importance items. But at the end of that, if we get through one and we have 39 more to go, I think it will be very clear that we have some schedule implications. So kind of at the conclusion of that July 12th meeting, we will make an assessment about whether or not we feel it's appropriate to formally communicate to everyone whether or not we are still on schedule for a September handoff to the council. So this is kind of the plan for the plan at this point. We wanted to share this with everyone to give you an opportunity to give us some input as we prepare for this July 12th meeting. I also want to point out that the calendars right now have August as kind of potential alternatives for us to continue these discussions. We have been working very hard to assess the feasibility of adding additional meetings to the Planning Commission schedule, and August is at this point quite problematic. So I think I want to make sure that we're kind of communicating what we know as we know it, and there are definitely some challenges with meeting in August. So I'm not here to tell you that we aren't meeting in August. I'm not here to tell you that we are meeting in August, but I think based on what we know right now, I think it's unlikely. So questions from the commission about this information at this point? We have a lot of work to do, I think, between now and July 12th to make that a very useful, thoughtful discussion, but this is our current plan to meet our objectives. Yes, Cameron?
Well, I appreciate the chair's characterization. It's 100% accurate. And just to report, the commission leadership meets with the council leadership very regularly. We had that meeting earlier this week and laid out this exact same set of thoughts. Council leadership understands that this is a challenge to complete. They echoed what we heard at the joint meeting of do it right. And so putting together a reasonable schedule. We are on track at the moment. I think the chair is appropriately highlighting that there are some uncertainties at this point, and we'll know more in early July.
Yep.
We'll keep everybody up to date. If you haven't already, sign up for our email alert system. And that's a great way of staying in touch with the city to make sure you know what meetings are scheduled and when. Thank you.
Great, thank you. So with that, any other calendar discussion we need to have?
Not on calendar, no, ma'am.
Great. Do you have a
Okay.
report from council?
Sure. Debbie, you might want to turn off thank you very much. Yeah, brief report. As you walked in, number one, I hope everybody did sign in at our table. Usually we have a person there to ensure that happens. We didn't have one there tonight, so if you haven't signed in, please do so. We do need an accurate record of who attends the meetings. Out in the lobby, if you didn't notice, there's a product of some of the most intelligent people in Sammamish. 2 fourth grade classes at 2 different schools created a kind of innovative city of the future called Polyhedraville. Fascinating project. That was presented at the City Council this past Tuesday. Probably the highlight of the council meeting, I will tell you that. And I fully expect many of those kids to grow up and serve as planning commissioners and city council members. I want to thank Emily Arteche of our staff who works with those kids every year to help facilitate that process. And these are our planners and decision makers of the future. Just a few other notes as to what happened at the City Council meeting. They focused most of their time on community center and other park projects. Was a lot of public input that the council received. No decisions came out of the meeting, but they are working on both many different park-related subjects. We had hoped to present the results of the Economic Development Self-Assessment Tool. We ran out of time. That's been rescheduled for the next council meeting on Monday, the 18th of June. So look forward to that. That material is up on the city website if anybody's interested in it. There was also an attempted discussion at animal control. There's a new thing on that. There wasn't time for that, so that's being pushed off. And recall that at some point the council will reprise its discussion on transportation level of service. That will come to the commission as well once you're done with ECA. So I'll keep the commission apprised as to that when it gets scheduled. That's my report. Any questions?
Seeing none, I think we're ready for a public comment. So just a quick reminder to everyone, tonight's agenda will have public comment, then we'll actually have a presentation on our 2 new topic areas, which are erosion and an erosion hazard near sensitive water bodies, and I think landslide as well. So we'll do a presentation, and then we'll have an open house where we'll have an opportunity to ask more detailed questions. We will not have a second public comment session after the presentation, so if you'd like to give public comment, I think there is a sign-up sheet, Cameron, is that correct?
We do have sign sheets back here, both sign in and then the notes here. Would you
Did
like
anyone sign up for comment tonight?
to- A lot of yeses here, yeah.
Oh, would you like to bring that forward? So we'll go through the list in order. Please start with your name and your address, and then we have a 7-minute time limit. After we're done with the list, if anyone has not signed up, you will certainly have an opportunity to speak.
I'm not sure which list is first, but I'm going to just put that one
Okay.
on top.
Well, Barbara Robbie seems to believe that she is first, and we are starting with that. So, Ms. Robbie.
I was the first one here, so. Barbara Robbie, 21421 Northeast 6th Place. I just want to put an article in the record that was in the Seattle Times, and it's by Elliot Menashe of Greenbelt Consulting, and it's just a very common sense way of dealing with, he mitigates steep slopes and hazard areas after they've been clear cut, and he has some good common sense guidelines for what to do before they get to that stage. When we get into all the technical items, sometimes it goes way over my head. This is just real common sense and easy to understand, so I'm going to submit that. And then also, I submitted a photo last meeting of the top of 211th Northeast, and where variance was allowed on a steep slope, and there was supposed to be an explanation as to why that was granted tonight, so just reminding folks. Thank you.
Thank you, Ms. Robbie. The next person on the list is Ms. Frazier. After Ms. Frazier is Mr., I think it's Krabby?
Yes, correct.
Krebby, thank you.
Hi, my name's Heather Frazier. I live at 611 208th Avenue Southeast. I would like to express my concerns and give some background information on my current situation concerning the ongoing development and its impacts in the area. While I understand the need and, more importantly, desire to develop land, I now unfortunately also understand better the repercussions of development. And due to the development of the land around me, I have lost the ability to develop my own land and, more importantly, have lost and am continuing to lose land as well as the use of my land. When I moved to Sammamish in 1999 and bought my 3+ acre property adjacent to the ravine containing Ebright Creek, I was enamored with the amount of trees and undeveloped pasture land around me. A few years later, a new neighborhood, the Arbors, began development. While I did notice an impact on the amount of water that my property started to have, I didn't think too much of it. However, when Chestnut Lane was in its infancy and an easement was granted underneath the road in front of my home was when the real problems began. While my neighbors and I took great care to determine which trees could be salvaged during the process and worked with the city and the water district to ensure the trees would be saved during the construction process, our efforts were ignored. A large cutting truck plowed down the road and took out all the trees within its reach. While I suffered through the construction of the sewer and water lines being placed under the road and the damage done to the vegetation around the site, I still had faith that both the developer and the city knew what they were doing. Once construction of Chestnut Lane began, I started to notice a large increase in the amount of water that was accumulating on my property. I have a gravel turnaround area that developed sinkholes, and the retaining wall around it also began to fail. I noticed a significant increase in the amount of water over my driveway, but I also noticed an increase in water that appeared from virtually nowhere, as it was now coming from underground. At this point, I started to become concerned. In 2008, when the application for the development of Greenbrier was proposed and included an infiltration system, I became downright scared. I voiced my concerns, along with my neighbor, to the city concerning both the development and the infiltration system. Being directly downstream from the development, logic provided that the water could only have one direction to go, and I was in the path of that direction. At the time, the detention pond for the site was on 212th Avenue, which seemed like it was a little bit away, and I was assured that the infiltration would be greatly dispersed before reaching my property, and that not only was infiltration a tested remedy, but that I would end up with less water on my property. It was stated that the Ebright Creek ravine was 60 feet high and therefore required a 60-foot setback. The plan proposed was for a 500-foot setback from the Ebright Creek ravine and would allegedly exceed minimum requirements and provide adequate distance for seepage to occur. My further concern was for overland water that would be put onto my property due to the proposed sewer collection and the infiltration system. I was assured that not only would the seepage not impact me, but theoretically I would have less water coming across my property. When asked what my recourse was should their theory fail, I was given the following in writing. During development build-out, the applicant is required to comply with strict regulations and inspection oversight by Washington Department of Ecology and City of Sammamish to protect downstream properties from drainage and erosion control impacts. The DOE can levy severe monetary penalties, up to $25,000 per day, for violations and aggressively requires applicants to resolve violations quickly. The City of Sammamish requires a signed restoration agreement along with assignment of funds and a surety bond covering 30% of the full costs of grading, erosion control, and right-of-way improvements prior to construction. The city can take the assignment of funds and surety bond to resolve violations in case the applicant does not resolve quickly. Also, the city can withhold final plat recording, building permits, and release of maintenance bond for additional leverage. I unfortunately incorrectly assumed that the city, the developer, and the existing laws would ensure that I was safe. I was not protected. The detention pond was not built where it had previously been proposed. Inspections were not correctly performed. Development continued forward, and as a result, I have suffered the consequences of being directly downstream from this development. In March 2011, a major landslide event occurred on my property. This landslide was reviewed by two separate and independent geotechnical engineers and has been classified as a toe slope failure. To clarify, that was not an overland erosion event where water came overland, but instead a failure at the base or toe of the slope due to an elevated amount of water in the underground water table. This slope failure caused a significant landslide that not only impacted the loss of my property, including a deck as well as a large amount of land, but it included the loss of use of my property, in that the city requested that I no longer use my driveway or my garage. In addition to the consequences I suffered, the slide also caused further damage downstream. Much to my alarm, development of Greenbrier continued forward, and to my greater alarm, the detention pond and infiltration system that was originally proposed to be along 212th was built directly across from me along the road, 208th, my road. In February 2012, I informed the city that the amount of water on my property was at a record height and that I was experiencing water in places that had never seen water previously, and I was also experiencing issues where a previously very small pond on my property had grown so large that it was overflowing onto my driveway. In March 2012, I made another urgent call to the city stating that not only did it appear that more water was on my property coming from underground sources, but the developer was actually draining water onto my property, causing an overland flow as well. I expressed my concern that the water had reached catastrophic levels and that I had major concerns that further landsliding may occur. The city did quickly respond, but they seemed a little bit more concerned with the turbidity of the water, while I was more concerned with both the amount of water and the fact that there was water. The large amount of water coming onto my property from both overland and underground sources started to cause large rifts in streams and eventually resulted in a second catastrophic landslide. This landslide was a result of the soils being oversaturated and the underlying soils unable to hold the weight. This second slide was witnessed by both myself and Tawny Hogue of the City of Sammamish. This slide caused the ground to drop by approximately a foot or more and a large mud flat to appear on the property. The resulting flow took out trees, bushes, and another significant amount of soil. While the developer of Greenbrier capped the pipe that was draining directly onto causing the overland drainage, the damage had already been done. In addition, I now have a constant flow of water from multiple underground streams on all slopes of my property, not just the existing slide slopes. These are all new and have only developed within the last year. These streams are all still putting out a very large amount of water, leading me to believe that the hydrology of the underlying water system has been disturbed and now has changed. I don't believe this was taken into consideration. I believe that it was assumed that controlling the overland surface water through sewer and infiltration systems would be sufficient, and the attention to the underlying hydrology was not given enough credence. It is possible that had the detention pond been put on the originally proposed site, this problem may not have occurred. There might have been enough land between the pond and my property to properly disperse the water underground before it reached my property and ultimately reached the ravine at Ebright Creek. Unfortunately, due to poor planning and the decision to move the detention pond within 15 feet of my property, disastrous results have occurred. The infiltration testing that was done to ensure that the downstream property owners would allegedly not be impacted was completely negated by the relocation of the pond, and the digging and the compacting of the ground during the development caused many unexpected results, the least of which is the damage to my structures and to my property. In addition, since water is flowing underground and these underground streams cannot be seen, testing does not ensure that water will flow where we suspect it will. Development is a necessary aspect of furthering our community. However, attention to the consequences of development must be taken into consideration. And not only the consequences the development has on the site being developed, but the repercussions on the downstream property owners. Again, I would have loved to be able to develop my land, but that opportunity has been stripped from me. I no longer, not by my doing, not by Mother Nature, but by the actions of others who are developing without due diligence and consideration. In addition, my right to just use my land has also been taken away from me and put in jeopardy due to these events. I strongly urge the committee to take into consideration prior to making any further decisions regarding erosion control and development of lands that will impact downstream property owners. Wow, sorry. Thanks.
Thank you. So I'd like to note for the commission that we have hard copies of the testimony that was provided today.
Thank you.
Thank you. Yes. Mr. Krebby? And after Mr. Krebby, Mr. Osgood.
You know, I'm here this evening to, I guess, monitor and comment on the presentation.
Name and address,
Oh,
please.
my name is Greg Krabby, 1726 Holbrook Avenue, Everett, Washington. So again, I was here this evening to monitor and comment on the presentation from AMEC, so it would be a challenge for me to do that prior to the presentation.
All right. You're welcome to provide public comment at our next meeting as well. Thank you.
Okay, thank you.
Mr. Osgood. And then Ms. Richardson, and then Mr. Radaba, and then Ms. Tiliakos, if you would like to provide comment after Mr. Radaba.
My name is Jim Osgood, 19661 Southeast 24th Way in Sammamish. I do have some comments related to the report, but I'm going to go ahead and give them to you now because I think next week is going to be a little bit too late after the recommendations already come out. I did a thorough review of the report that they're going to be presenting today. And first of all, there needs to be a balanced approach to ensuring Lake Sammamish is protected from increased sediment and chemicals resulting from erosion. Comment 123 from GFK Consulting outlines a plan that will do this and should be carefully reviewed by the Commission and staff. If a property owner within the overlay can demonstrate that there is little or no risk of erosion from the improvement or development of their property that will impact Lake Sammamish, they should be allowed to improve or develop their property. Secondly, in reviewing the report and the references, I had a hard time finding very much science in this report. If you take a look at the references, it doesn't really demonstrate that there's any peer-reviewed science, and that's basically the definition of best available science. I also took a look at the best available science used in 2005 regarding the erosion hazard in sensitive water bodies, and found that most of it related to either landslide, stream bed erosion, or very general information. Nothing to indicate the need for extreme measures dictated in the erosion hazard near sensitive water bodies overlay. I hope you will take a look into this science that was used in 2005 as well. I believe it is an overreaching policy decision that was made by the city of Sammamish and not one based upon science. In the report, I'm going to quote, AMEC recommends including language stating that qualified consultants, civil engineers, or geologists licensed in the state of Washington will field locate the extents of the no disturbance areas, and that result will be subject to city review and proposal. And approval. That was on page 9. I find that statement very unclear. I don't know if that means it's just the boundaries or if it's also the properties that are within the no disturbance area. The report recommends redefining where the erosion hazard or sensitive water body overlay begins with a 15% grade. It's on page 9. 15% is not a steep slope. The erosion hazard or sensitive water body definition assumes steep slopes. In our current code, we have a definition of where it begins as the steep valley walls, and that's in 21A 50 225 3A, and the report also references that on page 4. Best available science defines a steep slope as a slope of 40% or more. The definition should also include soils types, as well as whatever percentage of slope the commission decides is a reasonable steep slope. There should also be specified a distance and width in which the slope is over that percentage. A definition where the erosion hazard or sensitive water body ends should also be added. Current language is the downslope boundaries of the no disturbance area is the extent of those areas designated as erosion or landslide hazard areas. It should be redefined as the point where the slope is whatever that percentage that you have determined is where it begins, and it drops below that point. And it is also has to be for a specified distance, has the erosive soils and the extent of those areas designated as erosion or landslide areas. It should also be related to the natural flow of water. I'm sorry, that's a little confusing, but hopefully you can follow me on my handout. Much of the current erosion hazards as water bodies is not steep slope. The water flow is not directed towards steep slopes. Shouldn't there be the ability to prove an exemption within the no disturbance area? What about slopes less than 40% that drain into a city stormwater system? The report language related to the no disturbance is a bit misleading. I'm quoting the report. AMEC found this definition to be consistent with other municipalities' descriptions of the erosion hazard areas. That's on page 8 and 9 of their report. There are no other no disturbance areas in other statewide municipalities. All other municipalities permit development in erosion hazard areas subject to generally accepted erosion control methods. This is a policy decision that has been made by the city of Sammamish and not one based upon best available science. Also in the report, AMEC says generally best available science for protecting sensitive resources requires buffers and offsets and does not support increasing risk-associated activities proximate to the resources. For these reasons, we do not recommend changing the restrictions of SMC 21A 5225, and that's on page 3. I did not find any best available science related to this comment. It's my opinion that this is more an opinion than an actual best available science. In fact, the Department of Ecology has approved 6 technologies for general use in treatment of construction runoff. And that's also from the report that's on page 3. A new development that drains into the no disturbance area must set aside 25% of the site as open space, and the imperviousness of the site is limited to 35% of the gross site area if they cannot 100% infiltrate. 100% infiltration is generally not possible in Sammamish with our glacial till and hard pan soils type. This is reported in comment 132 from a geologist, Icicle Creek Engineers. In addition, it is necessary if it drains directly into a city stormwater system. And there should also be the ability for the director to allow improvements and or development if evidence is provided by approved experts that there would be little or no risk of erosion to Lake Sammamish. And finally, I'd like to suggest that all the commissioners do a drive-by at least of the erosion hazard area. And in particular, I would love to have you drive up and down 24th Way so you can get a better idea of why we are so upset about this whole process. So thank you very much for your time.
Thank you, Mr. Osgood. We have Ms. Richardson and then Mr. Rodabow.
Sure.
Oh, I'm sorry, we have a question for you, Mr. Osgood. Hold on.
One of the strategies that was used in Town Center to be able to handle the stormwater runoff was rainwater harvesting.
Mm-hmm.
Will you be addressing any of the other techniques that might be available to get to 100% saturation, like using it for rainwater harvesting?
I am not an expert in that area, but that is something that would be very interesting to look into. Our concept was to do a low impact development and basically reusing rainwater for clothes washing and toilets and irrigation. So we also, in our plan, we also have a what do they call a rain garden to be able to help with the infiltration as well.
Thank you.
Just real briefly, I'd like to make a comment that there are about 10 people signed up in addition to whom we have already spoken with or heard from. So just to give you a sense of the amount of time that might take up for both commission and citizens. So if you can be brief, we would appreciate it, but we also definitely want to give you the time to say what you think we need to hear. So thank you.
Thank you. My name is Susan Richardson. I live at 19661 Southeast 24th Way. I have given public comment on several occasions to both the Planning Commission and the City Council regarding our property, which is within the erosive hazards near sensitive water bodies overlay. This opportunity that you have to revisit the code provides a critically important opportunity to consider the issues and impacts of regulations on all the critical areas. The erosive hazard near sensitive water body is particularly unique because it summarily deprives the property owner from doing anything with their property. No discussion, no appeal. As a property owner and attorney, I feel compelled to remind everyone that the Fifth Amendment of the Constitution states that no citizen should be deprived of life, liberty, and property without due process, and when property is taken for public use, compensation should be given. This is a very serious business. The erosive hazard near sensitive water body overlay basically takes away a property owner's land without an opportunity to object and defend through due process. While it is certainly within the government's right to regulate property, there are constitutional limits on that authority. The Washington State Attorney General's advisory opinion in 2006 discusses the need to avoid unconstitutional takings of property, including regulatory takings. Without going into too much detail, the advisory opinion discussed the need to balance the government's intended purpose in a regulation with the means to accomplish that purpose and the financial impact on the landowner. Severe impacts, unclear government purposes, and less intrinsic means for accomplishing the purpose can tip the scale in favor of a determination that a taking has occurred. To create a no disturbance zone and enforce it simply because of its location on a map deprives each property owner of the right to address the regulation as it pertains to their specific property. This overlay contains many different types of property. In our case, we argue that our topography doesn't even warrant location in the no disturbance area. When we purchased the property 29 years ago, it was zoned R4. It still is. The financial impact of this overlay on us is extreme. However, even property owners who are not considering development may object to being deprived of the right to modify their homestead without being able to address the purpose and means of the regulation. Best available science defines an erosive hazard area by soil types and slope. The purpose of the overlay is to protect the lake from sediment and chemicals, especially during a development. Property owners should be given the opportunity to challenge the relevance of the regulation to their property and demonstrate that there are less intrusive means of protecting the lake rather than summarily preventing them from doing anything. If a property owner is not given the opportunity to prove that they can meet the purpose of the regulation, then one might conclude that there is another purpose or agenda which might indicate that the land is being taken for a public purpose necessitating compensation. The city has the opportunity and responsibility to address the overlay and integrate mechanisms that protect both the environment and the rights of each property owner. Both are important. I thank you for your time and the time that you take voluntarily in making the effort to deal with this important issue. Thanks.
Thank you. We have Mr. Rodabaugh, and then Ms. Tiliakos, and then Mr. Brockway.
Good evening, Sam Rodabaugh, 1905 to 16th Avenue Southeast. I'm also providing comment as legal counsel on behalf of Jim Osgood and Rob Capella. They are owners of real property in the city's no disturbance area within the erosion hazards near sensitive water bodies special district overlay. Now, this special district overlay is an outdated vestige of King County governance that predates the city's incorporation. It was based upon a 1994 study of Lake Sammamish. And at that time, stormwater and erosion control regulations were inadequate to address some emerging concerns regarding water quality on Lake Sammamish. However, in the intervening nearly 20 years, the regulation of stormwater and erosion control has increased by orders of magnitude. There was a letter that was provided in the record from GFK Consulting that I thought provided a very good overview of the increase in regulation on stormwater and erosion control in this intervening period, referring to the 2003 municipal NPDES permit, which is compliance with the Clean Water Act, 2 updated versions of the DOE Stormwater Management Manual, and the 2011 DOE construction stormwater general permit, which has also resulted in a sea change for the development community. Now, the sea change wrought by these regulations was not directly addressed in the city's best available science report. And although AMEC's work is often commendable, I must say after reading this specific report that it can only be characterized as having a dearth of both science and at times even logic. Now, I don't expect AMEC to address the law, but there are also some significant legal concerns with the report. First of all, the Growth Management Act establishes 5 different categories of critical areas, which include geologically hazardous areas. And those areas are defined as those that, quote, because of their susceptibility to erosion, sliding, earthquake, or other geological events, are not suited to the siting of commercial, residential, or industrial development consistent with public health or safety concerns. So the purpose of a geologic hazard area is to protect against public safety. It's not a safe place to build because your house will slide. Nothing in this report deals with safety. It's purely about sedimentation issues in Lake Sammamish. So really, these geologic hazardous areas are not a good fit for the public problem that we're talking about. But more importantly, there are WACs that govern geologically hazardous areas. And one of those subcategories is an erosion hazard area. And those regulations state that when quote, when technology cannot reduce risks to acceptable levels, building in geologically hazardous areas must be avoided. In other words, if it is technologically feasible to reduce the risks of development, then the city cannot require avoidance of impacts. And there's no question that the imposition of a no disturbance area is an impact avoidance mechanism. So the city's current code is in direct conflict with regulations that govern geologically hazardous areas. And interestingly, the report from the city's consultant, AMEC, concedes that it's technologically feasible to reduce the risks of development to acceptable levels. Quote, it may be technically possible to develop a site without impacting downstream resources through implementation of robust temporary erosion and sedimentation control plan with site monitoring, contingency plans, and other measures. Likewise, another document in the record from GFK Consulting reached the same conclusion. We all agree it's technologically feasible to avoid the risk and allow development here, and the no disturbance area as currently constituted doesn't allow that. As stated by the prior speaker, it also raises significant concerns regarding takings law and substantive due process, and in this state under RCW 8202020. Now, in my mind, the purpose of this evening is to hopefully recognize that there are some serious practical, regulatory, and legal concerns regarding the city's current regulatory regime. I doubt that we have the time and the ability for a back and forth to solve those problems tonight. My past experience in working with the city is sometimes a meeting with our planning director, Mr. Gurl, and city staff allows for a greater back and forth and the ability to share various ideas and brainstorming that may result in a creative, more practical approach to regulation. I'm here tonight to ask the Planning Commission to give their endorsement for myself, other attorneys that you will hear from that are representing clients, and any other stakeholders to hold a meeting with our planning director and city staff for the purpose of brainstorming some other ways that these concerns regarding erosion hazards can be regulated. I think that would be very productive and allow us to hopefully come back by your next meeting or the following meeting with some recommendations that perhaps all of us could support. Thank you.
Thank you, Mr. Rodabaugh. I understand Ms. Tiliakos is not interested in speaking tonight, so we have Mr. Brockway, followed by Mr. Kipp, and then Mr. Morelli. Is it Mr., Ms. Morelli? Mr. Thank you.
Is this the guy?
Oh, here it is. Okay. Thank you. Reed Brockway, 167 East Lake, Sammamish, Shore Lane, Northeast. I appreciate there's a lot of people testifying tonight, and I'm not going to be very long here, but, and I have a series of questions about the process that I'd sure like to understand. And ordinarily, I would be inclined to defer on that, but this process is cranking along at a good clip, and I'm afraid if I don't have a chance to bring it up tonight, then when? So if you'll please bear with me. I think you know what those questions are going to be, because I sent out an email yesterday to the city's standard ECA distribution list, which you all perhaps have seen, which included the questions and the reason that I was asking them. And what I'd like to do tonight, if I may, is not repeat that email, but just show you a couple, thanks very much, a couple of slides and go through this quickly for the benefit of those in attendance who probably are not aware of what this is all about. They're just 2 slides, by the way. Thank you very much. This is from one of the staff recommendation memos. There have been a few of those out. And this is describing what kind of work the staff is going to do in response to some of the recommended amendments that were submitted by the public. I'll go through it real quickly. Additional staff analysis and research will be conducted on the following: how the proposed amendment would be supported by best available science, ease of use for city and applicants, how to ensure consistency between applications over time, and adequate record keeping, and identifying the policy basis for the amendment. That seems like very worthwhile work, but it raises the following questions. And perhaps what we were told at the beginning of the meeting tonight about the risk analysis document speaks to this, but I have to say I'm not entirely clear the extent to which that is the case. For example, I'm not certain when you say we will be preparing a risk analysis document, who the we is. Is that the Planning Commission? Is it staff? Does it involve the public at all? What really is it? And perhaps if these questions could be answered, I'd have a much better understanding, as would others here, as to what this risk analysis document is. So let me just go through these briefly, and then I'm pretty much through with my testimony. When will this information is referring to the work the staff is doing, as in the previous slide. When will this information be presented to the Planning Commission, and will the public have a chance to review and comment on it in advance of the deliberations to which it is input? Now, if these could be answered as I go through them, that would be great, but at the very least, I'd hope that perhaps during the formal part of the meeting, we could get answers to these so that all of those in attendance tonight would have benefit of those answers.
Please review them, and I'll provide a brief comment when you're done.
Great, okay. Second question, will the Planning Commission revisit the testimony that introduced the amendment, or will the staff's much abbreviated versions, plus staff's input itself, be the sole basis for the deliberations? Will there be an opportunity for dialogue between the Commission and the party who offered the amendments to provide clarification and work out any bugs? And finally, will the Planning Commission accept alternate draft text from the public for those amendments that made the cut? Are these the things that the risk analysis document will be addressing?
So the discussion and the documentation that comes out of the sessions in July are intended to address these items, and they will all be provided before the public hearing. So I think that addresses your question about timing to some degree. Right. And I would request that after that first meeting on the 12th, that you provide us with some feedback about whether or not we met your personal standard for these things.
Will that feedback have to be in the form of testimony, or will you accept it out of sync, if you will, from the standard meeting process?
So we will continue to maintain a formal process for the public meetings for public dialogue and testimony. There may be other mechanisms that we use to interact with the public, such as the open house that we have later tonight, and some other things that we may consider going forward. But there is no more information that I can provide at this time relative to that.
But if
I
I
think it's
understand-
really important to note that the public testimony process that we have right here today and that we will continue to have is our opportunity as commission to hear your testimony in person as a commission collectively. And we need to really make sure that we maintain this as our formal communication mechanism. There are many informal methods of communication as well, but this is the formal public process, and it's very important that we maintain that for both the public, the commission, and those that are not able to participate in the meetings, or in those other meetings.
Sure.
Fine, just to wrap up here, excuse me, Mike, were you going to say something?
I just wanted to make sure and mention that the planning commission always takes on written comment. And
Absolutely.
Anybody can submit that at almost any time.
So our intent is to not, so two things. One is, our intent is to not get into a question and answer or a public dialogue in this forum. I want to be really clear about that, okay? There are other opportunities for that dialogue. I think the previous commenter provided an example of some of the ways that that's been done for other topics. But we absolutely request that you provide your comment to us in a format and a forum that it's available to all commissioners in the same way so that we can all hear and understand and take that into account when we go into our deliberation. That's really important.
Okay. Just to finish up, I'd have to say I'm not sure I'm clear on the answers to 3 and 4 especially.
So I'm not giving you an answer to 3 right now. I think we need to have a dialogue about whether or not we want to create that kind of opportunity, and if we do, how that might happen. And number 4, you are always welcome to provide any information in your comments to us, including proposed language for amendments.
Well, there's one thing to provide it and quite another to have it really become internal to the process and not simply something that is a courtesy. So I hope that there's some opportunity for dialogue in that regard.
I certainly hope that everyone in the public knows that the commission is listening to you not just as a courtesy. I actually am a little bit offended by that comment. I think we've tried very hard to be very thoughtful about all of the public comment that we have received and are not taking this lightly.
I appreciate that. I guess the proof of the pudding will be evident in time.
That's exactly right. Thank you.
Much.
The next person that we have is Mr. Kipp. And after Mr. Kipp, we have Mr. Morelli and then Ms. Gee.
Thank you, Commissioners. My name is Gregory Kipp, address 3011 211th Avenue Northeast in Sammamish. I've spoken to you in the past with regard to the issue of density calculations on properties that have critical areas and have provided you with information on the City of Sammamish's regulations relative to other jurisdictions in King County. I've had a couple of meetings with staff and have been understanding their concern about the need for thorough analysis and the possibility of a comprehensive plan amendment for any such change. As part of those conversations, we've been discussing the opportunity for limiting the scope of the initial request. And I guess what I am here to do today is to, one, advise you of those discussions, and secondly, as a previous speaker said, to seek the endorsement of the commission to continue those discussions and in the future bring back a limited scope proposal on how certain properties could be given more fair property rights than currently exist. As you know, if you have critical areas, those properties are subtracted from any density calculations and potential yields on the property. That's in addition to all the critical area regulations on which those properties are going to be subject regardless. So thank you very much. Appreciate it.
Thank you, Mr. Kipp. We are taking all of the suggestions for things that are not in scope, and we will be reviewing those as a commission as part of the deliberations. Mhm. So we have Mr. Morelli, Ms. Gee, and then Mr. Eastman. We have a picture. Perfect. I will note that we're about 25 minutes behind schedule, so we will be starting the open house a little bit late.
This is a story about how one family has been affected by some of the restrictions that some of the other speakers have mentioned. Good evening, ladies and gentlemen of the Planning Commission. I'm Pamphilo Morelli. My address is 11911 Northeast 1st Street, Suite B101, Bellevue, Washington. My brothers Dante, Robert, and I own the property located at 3620 196th Avenue Northeast. We purchased our property in 1965. That's 47 years ago. We've owned the property. We own a shy 10 acres. The property also has a home, barn, and sheds. It has been occupied during our ownership. In 1978, we drilled a well for water. The well driller found a supply of water after drilling 225 feet. He had to penetrate dense, hard pan before locating a good source of water. The soils are very stable, as our well indicates. We have no knowledge of any landslides in this area. The tall fir trees on our property show no indication of leaning due to landslide or slippage. Some of the trees are approximately 150 feet tall. In the late 1980s, some property owners began discussing the need for water and sewer for this area. In the 1990s, my brothers and I joined other property owners to form an LID. The LID was formed to the Sammamish Water and Sewer District. Under King County zoning, we were zoned R4, hence 40 lots possible. The LID allowed for 10 water and 20 sewer connections. Including interest, the total cost to our family was approximately $175,000 for the improvements. In the middle 1990s, King County designated our property and most properties between the East Lake Sammamish Parkway and the plateau with a P suffix and an SO 190 category, sensitive overlay status, meaning that none of these undeveloped properties could be developed because of slopes greater than 15%. All properties between 15 and 40% were all lumped together because of slopes, ravines, water courses, types of soils, and landslide potential. The next comment I have is a side note. This is prior to the formation and the incorporation of the city of Sammamish, so don't take offense to this. What I'm trying to do is just prove a point. Most everyone here tonight is familiar with the 500,000-gallon water tank reservoir that was constructed on the Freeze property in 1994 and 1995. That's the time period when the county was putting the sensitive overlay on SO 190. This water, by the Water District, this abuts the Buckham development of Old Mill Point, Weber's Ridge, and Chrysalis Estates. The tank is on 196th Avenue Northeast. The structure sits approximately 500 feet north of our property on about the 300-foot elevation. The consultants that the Water District had used had come to see me if the Morelli family wanted the water reservoir located on our property at an elevation of about 300 feet plus or minus. They were looking for a bench that they could locate that structure so that it could feed gravity-wise from that elevation. So to make a long story short, I'm sure they've had to done extensive soils testing, check for landslide potential, slippage, seismic, and engineering to be certain that the area was stable and safe and could support a structure of this size and weight. In all of our years of ownership, there's never been any soil erosion or landslides on our property. Our property has a 17% slope. And if you look at the map on the easel, the west property boundary is on the left side, and the east property boundary is on the right side. And that slope through that yellow area is about 17%, right at 17%. But some areas in that area, when you do the slope analysis, are below 15%. We consider the usable portion to contain about 5 acres, with the remaining to be left in a natural state, being too sensitive to develop. I have a topo survey, which is that, and it's included in the packet, which shows the different areas of the property and the slopes. What we are asking for is the opportunity to develop the center portion of our property that falls in the 17 or less slope. Our soils investigation was done by Terra and Associate years ago, which shows that our soils have a low possibility of eroding. If you read there's a short one letter from the soils company that just quickly tells you what the soils are. They're basically non-erodible, or very, if you handle your project carefully, it will not cause intensive problems. And with good construction management practices, our project could be completed with little or no harm to the environment. We have done a wetland study by Talasia Consultants to determine our sensitive areas. In 1999, the city of Sammamish was incorporated and continued King County's policies for a new no disturbance zone. The restrictions in place restricts the ability to allow development on a case-by-case basis and unfairly burdens these properties like ours, which can be safely and sensitively developed with reasonable mitigation measures. Through the years, the Morelli family has paid its real estate taxes, LID commitment, and paid for the future use through consultant surveying, engineering, soils investigation, wetland studies, and traffic consulting. In closing, what we would like is to be treated with fairness in the use of our land and to work with the city by discussing how we can best plan for 50% development within the scope of existing codes or to be modified by the city, so that longtime landowners of property that have been identified and encumbered since the 1990s by the sensitive overlay ordinances may be partially developed. Thank you for your consideration.
Thank you, Mr. Morelli. Ms. Gee and then Mr. Eastman.
Chair, hold on a second.
Oh, I'm sorry, we have a question.
I would have to say that the diagram that you have that shows the different color slope patterns is probably one of the most informative diagrams I've seen so far. I like it. It's a good diagram.
I'm sorry, I'm hard of hearing, so my
That's all right, I
my
can't
brother
talk anyway.
maybe can tell me the question.
The diagram that shows the slope patterns in different colors is very informative. Thank you for providing that. This one, I like it.
Thank you.
He really likes that diagram.
Oh,
I'm not going to make public comment because I know it's late. If you promise to read this as bedtime reading, I'll just submit it as
We
public.
promise. Thank you, Ms. Gee. Mr. Eastman? Following Mr. Eastman, we have Mr. Rosenlund and then Ms. Rosenlund. Should Ms. Rosenlund choose to provide comment? Is that a no? No. Okay. You're welcome. Thank you. I have to say the commission very much appreciates the hard copies and the written comment. It's very useful for us. And the comment in advance. That's also very useful.
Hi, I'm James Eastman. Actually drove from the Tri-Cities tonight, and we'll be driving back after the meeting. Address is 4607 Segovia Drive, Pasco, Washington. Partial owner of Sammamish parcel 1925069-028 off of 196, just down from Mr. Morelli. And I was hoping not to come tonight, but I really didn't see the city address any prior concerns that I had in the approval of an RUE and also the city's consultant. So I thought I'd come tonight to make some concerns known with the code itself. And, you know, I did have an RUE approved with the city. I must say the city staff was excellent to work with. But I believe the code is greatly flawed, and their job is to back a flawed code, which ultimately cost me a significant amount of money.
So just briefly, when you say RUE, you're referring to reasonable use exception, correct?
Yes.
Thank you.
Which I went through the necessary process, about a 2-year process, to get an approved RUE. To begin with, the landslide hazard code basically says anything over 20 feet with a 40% slope is a landslide hazard. We're calling this a hazard, but nowhere in the code does it say we can remove a hazard. So it's like having a power line on the ground and we're building a fence around it rather than getting rid of the hazard. We're calling it critical area. We're protecting it. So that's my first issue with the code. And because of that, because we're protecting these hazards, we're not allowing them to be modified. We send people to an RUE process. And part of the problem I had with the city's comments leading into this meeting is they said, hey, the RUE process has nothing to do with the critical areas. And I'm going to show you tonight that they're intertwined. Okay, so an example I gave in my comments already submitted to the city is if you had a pile of dirt on a lot 20 feet high and you wanted to build a house on it, what would you do? Common sense says you take the pile of dirt out and you build your house on a flat spot. But you just remove the landslide hazard, which Sammamish code does not allow. You must submit for an RUE, which calls for minimum disturbance to that pile of dirt, which says you're building on the side of it. And essentially, if you turn to page 3, which is my topo map, this is my approved RUE. This is sheet C3. The area with the colored lines with the shading there, that's a critical area. That's a landslide hazard. As you can see, I've highlighted the coloring. That's my pile of dirt. I wanted to remove that dirt, remove the landslide hazard, have it gone completely, and build a house on a flat spot. The city says, no, the RUE code says minimal disturbance to the critical area. You cannot remove that pile of dirt. Go to the area with the least amount of landslide hazards, and that's where you're going to put your house. And that was basically the 4th proposal is what I had approved through the city, which is where you see the house now. So it could have been on a flat spot if they would allow me to touch the landslide area. But the code says you can't. I mean, I don't fault the city, I fault the code. Nowhere in the code does it say you're allowed to modify a landslide area or remove a hazard. So after about $35,000, being the 4th study to put forth a viable plan, this is what we have. I've circled all the walls that I have to put in. Top of wall for the house is 206 feet. Bottom of floor for the garage is 186. That's a 20-foot difference. I'm putting my house into a hillside with all these walls due to this code, this flawed code, where I could have it on a flat area if I were allowed to remove a hazard. So that's basically my problem with the landslide hazard code. Now let me get into how going into an RUE just takes more money out of my pocket. If you go to the page before that, some of the public works comments to my RUE are listed. When you go into a reasonable use exception, it's a type 2 review, which means now my review is going to Public Works, it goes to the fire department, it goes to everyone, simply because I couldn't remove a hazard. Now I got to go through an RUE to minimally disturb that hazard. Public Works, now their first comment back to me was, you need to widen the road that you're on. I said, you're kidding me. This road's been here 100 years. Why am I widening the road for one house? I said, no. And they said, okay, well, we'll take a look at the road. And they said, okay, the road's okay. But you still need to have a turnaround. I said, a turnaround? I'm on the middle portion of the road. I'm not even at the end of the road. And all the people up at the end of the road who are building houses before and after me, they have plenty of room for a turnaround. They have a flat lot, but yet they're not putting a turnaround on their property. Why? Because they didn't have to go through an RUE, which means Public Works didn't have to comment on it. So Public Works is asking me to put the turnaround on my property, which is not protecting, which is not minimal disturbance. They're basically saying, oh, you have critical areas, we want you to do minimal disturbance to your lot by going into an RUE process, But then when we review it, we're going to cause more disturbance to your lot because we pushed you into the RUE due to minimal disturbance. So I fought that for a while, and I couldn't get away for it, so I ended up having to pay my engineers to design a driveway to have the proper radius in it that would also be the same as the city's hammerhead turnaround, which means the area that I could have used for my house to build my house is now being used for a driveway for a fire truck to turn around in. Okay, also the private road, the access to it down to East Lake Sammamish Parkway. It's been there 100 years. 3 other people have built on it before and after me. Public Works wants me to make sure there's adequate sight distance turning out of that road onto East Lake Sammamish Parkway. The road's been there. Other people are building homes. None of them are doing sight distance studies. Here am I pulling more money out of my pocket for a sight distance study for a road that already exists.
Mr. Eastman, please wrap up.
Okay, I drove a long ways for this, so I want to get this out. And then the erosion comments, I agree with everything. I thought the study was, there's no science available to support that. There's plenty of properties down from Mr. Morelli. There's a property with even less slope, maybe 10%, that because it is not on the top and it's not on the bottom, it's in between the areas. Their property rights have been taken. I feel the same way. The picture at the end of my packet, that's the area that I wanted to plant, remove. As you can see, you know, that's an erosive area and it's a landslide area. That's going to remain if the code stays the same due to the fact that you can't touch it, which to me is kind of an oxymoron because if you look at the picture, that has erosion and landslide written all over it. Thank you.
Thank you. We have Mr. Rosenlund, and then I can't tell if Ms., is it Favre, would like to speak, but if she's here, she's welcome to speak after Mr. Rosenlund, and then Mr. Sorensen.
My name is Leland Rosenlund, living at 19675 Southeast 24th Way, Sammamish. And my wife Sharon Rosenlund would like to submit this written statement that we agree with the 2 reports that are commented and compiled by Jim Osgood. We are neighbors to Jim and Susan and have the same concerns regarding the overlay map that has impacted our ability to do anything with our property. We have lived in the Sammamish area for close to 40 years and are very disappointed in the decisions that have taken our ability to do anything with our property. I would like to highlight points 10 and 11 in Jim's extended and extend Jim's invitation for any of the commissioners to visit our property firsthand. I ask that you would give me a call so I could meet with you in person to walk the property. Thank you for your time and your consideration in this matter.
Thank you, Mr. Rosenlund. Ms. Favre? Nope. All right, Mr. Sorensen, followed by Mr. Vanderbilt, and then a Mr. Martin.
My name is Bob Sorensen. I live at 22609 Northeast 2nd Street in Sammamish. For the record, I am speaking on my own behalf as a citizen. I am not speaking on behalf of any organization nor my employer. Most of you know me, know who I am, but I'd like to state for the record that I am an architect. I've been practicing for over 40 years. I'm licensed, and as an obligation of being a licensed architect in the state of Washington, I have to keep updated on current trends in technology and design and building techniques and so on. So when I heard that the city was going to hire a consultant to look into best available science concerning our critical areas, I was pretty excited that I would see some new technology of how citizens could use their property to the fullest advantage while at the same time protecting our critical areas. And yet, as I read through the various reports, the only science ever presented is substantiating buffers. Stay away from the critical area, and the critical area will be just fine. Well, any fifth grader can stand here and testify that the further you stay away from a fragile object, the less likelihood you're going to have of adversely affecting that object. That's not what it's about here. That's not science. That's common sense. What I would like to see is some science related to how we can best utilize our property, our resources here, while at the same time protecting these critical areas, and not just saying stay away from them and avoid them. So as you develop this new critical areas ordinance, I would like you to strongly consider the alternatives to buffers for protecting these. It was briefly mentioned in the latest report. Mr. Rodabaugh cited it, that yes, it's technically possible to develop a site without impacting downstream. Basically, it outlined techniques and policies that are already in effect, already used on just about every project that's built in a critical area, and yet they come to the conclusion that there's just too much risk to allow the ordinary citizen or the ordinary developer to take advantage of those technologies. Frankly, I find that insulting and demeaning as a land use professional. And yeah, I'm just very frustrated. And the bottom line is, if it's your intent as a planning commission to create an ordinance that not only protects our critical areas, but also allows for reasonable use of our properties, then you need to do a lot of work yet. You need to redirect the consultants to begin to provide some of this information that will allow you to make those determinations. On the other hand, if it's your intent that the critical areas ordinance be used simply to curtail development in the city of Sammamish, or somehow retain the rural character of an urban growing area, then that's an ideological battle that I don't think will ever be won, because nothing anybody here can say will impact you if that's your ideological position. So, ball's in your court. Thank you very much.
Thank you, Mr. Sorensen. We have Mr. Vanderbilt.
Is it possible to download a couple pictures, please?
Following Mr. Vanderbilt, we have Mr. Martin. That is the last person signed up for testimony tonight. I would like to be mindful of the fact that we are 45 minutes over, so we do want to provide the opportunity for everyone to speak. If you would like to speak after Mr. Martin, I suggest you queue up now.
I have a question.
Yes.
A client of
Please go to the microphone.
My client has spent some amount of, invested in having a limnologist here this evening to make a presentation on the water quality of Lake Sammamish as compared to urban growth in the region. And we felt it was appropriate to do it after AMEC's presentation. So my question is, will there be time, or should we do it now?
How long is the presentation?
7 minutes.
I would prefer that you do it after Mr. Martin speaks. Thank you for asking.
Okay.
This is not Mr. Martin, by the way. This is Mr. Vanderbilt, so
Prior to AMEC's.
prior to the presentation would be appreciated. And I think we have someone that will follow you. Yes, okay, I'm seeing nods. Thank you.
So do I just click on it?
Okay.
Good evening, and thank you for hearing me. My name is Duncan Vanderbilt. I live at 19664 Southeast 24th Way. I can certainly relate to many of the folks here who've expressed emotion and in confusion and maybe frustration around the topic tonight. I think that it's often hard to talk about when it becomes personal, so I'd like to maybe share a little bit about my story with you, because I think all these decisions that we have tonight, in fact, do have a personal impact to people. You know, I am surprised to find myself in a hazardous location. If you look at the property above, I don't know how many of the folks in the audience would consider that to be a hazardous slope. It's approximately 4%. If you put a ball out in the grass isn't even steep enough that the ball will roll down. And here I find myself, I believe, in error by the broad, in my feeling, careless stroke of a pen that's added me and lumped in with some concerns that are not accurate. I don't say this without experience. My degree is actually from the College of Environmental Design at Berkeley. I'm very sensitive in caring to all the impacts, but I can tell you that when I read the report, I was shocked. The quality of that was something that I could have really produced as a freshman without any schooling. I mean, common sense, to Bob's point. This is not the situation that you want to address, yet I find myself trapped and stuck here without an opportunity to address my concerns for the conflict between the facts and where I find myself. Yet a few hundred yards away on one of the steepest roads in Sammamish, I see this.
What road was the prior road, and what road is this one?
That was north, that was southeast 24th Way, and this one, I forget, I think it's, I need to follow up, I left my notes.
We'll provide that information later, that's fine, thank you.
Yeah, so, I mean, this is basically, a few hundred yards away from my home, and actually, to their credit, I think they're responsibly controlling the construction process. Just a little bit for context. So getting back to this picture, I'll tell you what that represented for my wife and me when we bought the property. My home is just to the right, and there's a nice field there. And when we bought that home, family is very important to us. As we projected what that field would mean in the future, as we in our family care for our parents, that location was going to be a home in which we could care for other members of our family with minimal impact to them, something that we could absorb. And now I find myself basically unable to meet some of my commitments to my family for really confusing regulations that I have no way of challenging, I feel, with the current information. So, at minimum, if there are means for folks to kind of challenge and understand and maybe address some of the concerns that you have, I think that's, at minimum, something that needs to be incorporated into the process. Thank you.
Thank you, Mr. Vanderbilt. Questions? No? All right. Mr. Martin?
Good evening. Larry Martin, 777 108th Avenue Northeast, Bellevue, Washington. I'm here this evening, again, representing the owners of the Probst Estates property. I appreciate the testimonies running long and appreciate your patience. I'm going to try to condense it down as much as possible and refer to prior comments. There's been several comments as to the nature of legal issues arising out of the overlay that is essentially a no development in an area designated by the map. It's absolutely true. It presents a real legal issue. The real point for us, though, is to try to figure out a practical solution. And I really like the proposal that those of us that are willing and are interested would meet with the planning director and staff to try to see if we can't agree on some common recommendations to bring back to you that would address this dilemma. I think it really is a dilemma. If you see the letters submitted by Mr. Krabbe, we really endorse those. There's a letter that was submitted either tonight or just very recently, and there was a letter submitted in your last meeting. I think both of those are really well reasoned. And in the letter tonight, he points out some of the problems with the AMAC report. There really isn't any support there for retaining that prohibition on development in the overlay. What the report says in simple terms is that it would be, if there could possibly be some more risk from removing the overlay, we shouldn't remove it. That's really what it says at its essence. It says, well, you know, there is the technology out there in terms of the various ways that people have talked about how you protect slopes and prevent erosion during development. Said, yeah, we can do that, but the fact is that sometimes there's errors, sometimes people make mistakes, so that presents some risk. So because of that, we should retain the overlay. Well, you could imagine, I think everybody there, you don't have to be a lawyer to know, you really don't have, that's not a good basis to go into court if somebody wants to argue about this overlay, and that's not where anybody wants to end up. And I think you have a very difficult task on your hands, just if you're just talking about the overlay. You're talking about other issues as well, I know, that you need to deal with. But for us, owners of a large area of property that really doesn't have much development potential if it can't be divided into smaller lots, the real issue is the overlay. Because my clients are more than willing to go through all the hurdles of site-specific studies, you know, following all the best available practices, coming up with designs that will design appropriate systems for that particular property, and have to bear the burden of proving to professional staff, and the city obviously always has the option of hiring outside consultants to review an applicant's proposal and to require us to pay for it. We're willing to do all of that. What we just can't accept is when no other jurisdictions feel it's necessary to use that drastic method of an overlay and a complete prohibition, essentially. I looked at Redmond's ordinances, and it's got areas that are similar to this along Lake Sammamish, and it doesn't have that proposal. The county no longer uses, and I didn't mean proposal, I mean that regulatory mechanism. The county no longer uses that. As Mr. Krabbe showed, there have been very large developments in Issaquah, very similar drainage into Sammamish. And there were specifically negotiated sets of regulations that apply to these big developments, and they don't use that, you know, that overlay. I didn't personally check Bellevue, but I believe that Bellevue doesn't. I've never heard of Bellevue using that either. So I think it is true that nobody else uses that approach. So the thing is, okay, it's creating a legal problem. It's really unfair in that it doesn't specifically address the issues related to specific proposals on specific properties, but, you know, where do you go from there? And so again, I think the prior speaker was asking for some kind of a nod of the head or something to indicate that the commission would, welcome the process. If some of us want to go meet with staff and planning director, and if we can come up with something to come back to you, I think all we're looking for is to say, sure, we'd like to see that. And then maybe the other issue was, well, what about the schedule? Does that mean we should have it in by X time period? I think if you could give us a little guidance on that, we would be more than willing to spend our time and effort and try to do that in a cooperative fashion and bring back what could be, you know, hopefully a solution.
Thank you. Your request is noted.
Thank you.
Presentation. Good evening. My name is Rob Zizette. I've been asked by landowners to speak to you tonight with respect to water quality in Lake Sammamish and the history of development of its watershed. I'm a water quality principal at Herrera Environmental Consultants in Seattle, and I have 30 years of experience Excuse me, while I pull up the presentation. Thanks. I've worked on several lake restoration projects and several analyzed development impacts to lakes throughout the region for 30 years. Let's just get on with it. Basically, what we're talking about, water quality in Lake Sammamish, is about eutrophication from human disturbance, and it's all about, since they diverted sewage from the lake, now it's all about stormwater phosphorus loading, which causes algal blooms, et cetera, as you are full aware. We measure it, eutrophication, using the Trophic State Index, which is a composite of 3 parameters, total phosphorus being the primary one, but also algal biomasses, chlorophyll A, and Secchi depth transparency. And then we use that index to rate lakes into 3 classes, ranging from good to poor. And this is just a graph of the 3 major lakes in King County, comparing Lake Sammamish to Lake Washington and Lake Union, where it falls in between, as would be expected given the extreme depths of Lake Washington and the shallow depths and urbanization of the watershed of Lake Union. But the point here is that the blue line of Lake Sammamish falls right on the border of mesotrophic and eutrophic.
Could you repeat that? I couldn't quite hear you.
The blue line of Lake Sammamish, it borders between a category of mesotrophic and oligotrophic. I'm sorry, I misspoke. But most recently in the oligotrophic range.
And that would mean what to people that are not familiar with those terms?
It's good versus moderate.
Thank you.
Clearer water quality.
Thank you.
Less beach closures and toxic algae blooms. At any rate, this was what recognized by King County in 1996, where they developed the water quality management plan for the lake and developed actual goals specific to this lake that are different than the state standards, that are based more on what they wanted the lake to be. And that includes, again, these 3 parameters, phosphorus, chlorophyll, and Secchi depth. But it also establishes watershed management and stormwater control requirements. This is the plot I wanted to show you. This is really the key of what is going on in the lake since 1994, and this is the average phosphorus concentration of the lake, where it's fluctuated but consistently been below the goal that was established in 1996. And most importantly, this entire line is a significant decrease statistically over time, but you can see the decrease since 1996 is quite astounding. Well, you plot that against the green line now is plotted against the other 2 straight lines, which are just a measure of the percent cover of urban development in 2 regions of the 4-county area that Heppenstall evaluated using aerial photography. Just the point showing that development has been increasing over the same time period as the phosphorus concentration in Lake Washington and Lake Sammamish is decreasing. And why? Well, it's because of stormwater management and improvements to that. Over time, the surface water design manual that King County developed in 1990 has been improved, most specifically in 2005, which occurred just before this last precipitous drop, where it covers smaller drainage areas and adds lots of erosion and other stabilization measures in it. We also have a general construction permit that was originally established in 1992, but particularly again in 2005, these thresholds were reduced to require contractors to implement erosion control and stormwater management. We also have the municipal stormwater NPDES permit, which was very vague when it was first established as by Ecology in 1995, but since in 2007 specifically identifies much smaller sites and requires annual inspections of those sites. Those all together have helped reduce the phosphorus loading to Lake Sammamish and improve water quality. Obviously, there's lots of different development variables that affect phosphorus loading from developments to the lake, either during the construction period or after the construction period. And these are all techniques that have been improved upon in the years and are available today. But the bottom line is, what doesn't affect phosphorus loading is how close you are to a lake and how wide your buffer is. That science is out there to show that it's stormwater goes into a pipe and it gets to a lake regardless of how big your buffer is in between the development or how far upstream you are in the stream. And with that, I'm done.
Wonderful.
Thank you, nice job.
Any questions? Great. All right. Our next speaker, please.
John Galvin, 432 228th Avenue Southeast. I have the unfortunate privilege of owning a piece of property in the town center. I'd like to commend the Commission for its openness and patience with the citizens. It's a quality that has not always been present in previous commissions and not as often at the council level as it needs to be. Regulations have consequences, and sometimes very serious consequences. We're trying to get a town center going. We've got businesses wanting to locate there, but we have the most onerous, stringent regulations in the state, sometimes in the nation. And the people that want to do what the city needs find it too expensive, too difficult. They throw up their arms and they just say, goodbye, we don't want to deal with this. So they have real consequences. The stormwater management is an example. They have a flow control level 3, the most stringent level. Our town center has the most stringent stormwater control in the nation. That was applied just blanket over the Thompson and the Ebright Thompson and the Inglewood basins without any consideration of how it might change moving from the lake to 2-3 miles away. A lot of the decisions that are being made because polarized and political thinking. Polarized, it's one size fits all. Let's solve it with, hit a nail with a sledgehammer. It's political in the sense that they don't benchmark, they don't look at things that other cities are doing, and a lot of the decisions, when you really look at them, ignore the data. I think one of the big problems, I have all kinds of things to say here, but I think one of the real challenges that we're facing is that Sammamish is not urban and it's not rural. So we end up applying urban standards to rural areas and rural standards to urban areas. What we really are is suburban, which is neither urban or rural. So when we have a piece of urban or suburban development next to a rural property, you don't have all of the urban standards to protect you, all right? And when you have a rural standard applied to what should be a town center urban, you can't do it. It doesn't work. And because we're suburban, we don't have the money to put in the systems that urban areas have to mitigate a lot of these problems. So we're kind of caught in between. Sammamish has about 2,100 people per square mile, and that is just barely suburban. It starts at about 2,000. Urban begins at 4,000 people per square mile. We have Mercer Island has 3,500 people per square mile. So we are really mixed, and that's why I think we're struggling with so many of these problems. We're not urban, but we apply rural standards to urban areas. We're not rural, so we apply urban standards, and that's that roundabout and all the roads you got to put in sidewalks, and you're in the middle of nowhere. So this is a real challenge for you. Let's not be political. Let's really try to synthesize differences and come up with solutions that are practical. Science is fundamentally practical, It gets things done. But it can easily become ideological. It can chase the dollar. It can be anything but objective. Thank you.
Thank you, Mr. Galvin. Next.
Good evening. Greg Krabby, 1726 Holbrook Avenue.
Right, you don't
Everett.
get to speak twice.
What's that?
You don't get to speak twice.
I haven't spoken yet.
You came up earlier.
Yeah.
You said you'd speak next time.
And, well, right, because I thought I would have a chance afterwards, and then I asked if it would be possible for me to speak now.
I'm sorry, I misunderstood your request. Please continue.
Thank you.
But please be more clear with me next time.
Understood,
Thank you.
understood. So I'm a civil engineer here in the Puget Sound area. I am the author of the GFK consulting letter that was submitted some time ago and has been referenced several times this evening. And tonight I'd like to speak briefly about AMEC's evaluation of the erosion hazard area, of course. In their Streams, Fish and Wildlife Habitat Conservation Area paper, AMEC summarized a series of physical and biological functions that take place within a wetland or stream buffer. These were water quality and sediment removal, water temperature, woody debris recruitment, and wildlife habitat. Scientific measurements of these qualities were subsequently used to establish effective values for buffer widths and were well presented in this paper as best available science for the city to make policy regarding these elements of the Critical Areas Code. In contrast, AMEC's erosion hazard area and erosion hazard area near sensitive water bodies paper contains no similar assessment of the scientific need for the no disturbance designation within the erosion hazard code. Instead, AMEC makes the following statement: generally, the best available science for protecting sensitive resources requires buffers and offsets and does not support increased risk-associated activities proximate to the resource. For these reasons, we do not recommend changing the restrictions of the SMC 21A 50-225-3B, which is basically the portion of code that is the no disturbance designation. This statement does not provide the scientific justification required by the Growth Management Act for imposing a no-build standard across significant areas of land. Buffers, in and of themselves, are not science. In their prior paper, buffer widths approximately between 150 and 300 feet were deemed appropriate to protect against sediment pollution based on scientific observation. In tonight's paper, effective buffer widths of 1,300 to 2,000 feet or a virtual no-build zone are suggested without scientific basis. AMEC does agree that the lake could be protected using current erosion control methods, but quickly discounts this as being too risky to consider, and does so without providing any basis for implying that the best available science requires all risk to sensitive areas. If that were the standard, land development could not be allowed anywhere. AMEC also fails to mention that no other jurisdiction in the immediate vicinity of Lake Sammamish imposes a no disturbance requirement as part of their erosion hazard code. Issaquah, Bellevue, Redmond, and King County all define erosion hazard areas identically to Sammamish, but all allow work within these areas under certain circumstances. Finally, according to AMEC report, the key concern with the water quality of Lake Sammamish is the transport of phosphorus into the lake. And we were going to have Rob make his presentation, which he has already done. So you've had the benefit of our position there. Again, we urge you to reconsider this no disturbance section in your code. Thank you.
Thank you. I think we have one final speaker. Anyone else would like to give public comment today, please stand behind the podium.
Rory Crispin, 3023 East Lake Sammamish Parkway Southeast, Maylene, P.O. Box 40443, Bellevue. The consultant's report suggests to add an option for the city to have third-party review of geotechnical reports in landslide hazard areas, citing WAC 365-195-905. That WAC is titled Criteria for Determining Information is the Best Available Science. So calling for a third-party review or study is a policy decision, not information that is best available science. This would just cost more money, though. In Sammamish Code 21A 50045, the fees section, it states, consistent with the city's adopted fee schedule, the city shall establish fees for application filing, review, and other services provided by the city for critical areas review. Basis for these fees shall include, but not limited to, the cost of engineering and planning review time, cost of inspection time, for administrative costs for third-party peer review, and any other special costs attributed to the critical areas review process. Unless, and it continues, unless otherwise indicated in this title, the applicant shall be responsible for the initiation, preparation, submission, and expense of all required reports, assessments, studies, plans, reconnaissance, and other work prepared in support or if necessary to review the application. Holy cow. Then it goes on, there's another section, 21A 50.130, contents of critical area study. This would be the report. The critical area study shall be in the form of a written report prepared by a qualified professional and shall contain the following as determined applicable by the director, and then it goes on to list a bunch of things. Recently, I saw that there was a council agenda item to budget money for an on-call as-needed engineer. I presume this would be covered under the reviewing fees listed, whether it be reviewed in-house or by a contract personnel. That ought not matter, but it ought to be impartial and above board, not a third-party peer review. I think that there must be fairness and impartiality regarding permit review. It is necessary for there to be impartiality in this process. But what is a third-party review? Does that imply there are other property interests other than the owners? What is the second party, or who is the second party? Is it the city, and is that impartial then? If a study report to a critical area is called for, and that report is created by a qualified individual, that being a person educated in the field of study and licensed by the state of Washington, why is there a need for a so-called third-party review? Isn't that really just calling for a second opinion? And it all has to be paid for by the property owner anyway. Why is a professional work from one licensed engineer better than another? Both are qualified and the same in the eyes of the state licensing board. But I hear in the case of wetlands, the city holds a preferred third-party list made up of companies or consultants that staff has worked with or worked for in the past, that may be buddies or pals, that they are working relationships and or social relationships with, but is a list that a property owner must choose from and pay for. What's fair about that, all that? Where is the impartiality? Why is that even necessary? Is there going to be a third-party list for geographic hazards now too? Why isn't anyone requiring the person calling for this so-called third-party review, requiring them to pay for it, instead of the property owner who already paid for the one? No one is suggesting that a third-party review of the consultant's work be done and have them pay for it. This third party is just another third party anything is just another example of adversarial language calling for adversarial relationships with the city and by the city. It needs to be removed. Any list or rules created under administrative discretion needs to be brought to light. Thank you.
Thank you, Mr. Crispin. At this point, I'm going to close the public comment period for this evening. I want to thank everyone for your thoughtful testimony tonight and for providing any written comments to us so that we can include those as part of the formal written record. I also want to clarify a comment that I gave earlier. I want to make sure that everyone understands that we do take your testimony very seriously. That does not necessarily mean that we will take action on everything that you request or that you will be satisfied with the ultimate outcome of this process, but we do very much appreciate everyone's time and energy. And you know, I think as a commission, this has been a very informative process, and I think tonight was quite an example. So I am going to change the agenda slightly. I understand that we have 2 members of the public that have decided to share their birthday with us instead of with their families, and that someone has brought cake for them. So we're going to take a 10-minute recess so that we can celebrate some birthdays. So thank you very much, and take a little bio break, and then we'll return and have the follow-on presentation, I presume. I suggest that the Director of Community Development would like to say something at this point. Do you have a suggestion on the schedule?
Well, I think that cake is the best idea I've heard all night.
Okay.
And it is unique that in Sammamish, people would bring something to a public meeting and choose to spend their time that way. Want to try to keep that to really a true 10 minutes and not a sort of 13, 15 type of
We
thing.
will start even if you're still eating cake.
That's right, at 8 o'clock sharp. We've asked the consultant to do their best job to do complete, but as speedy a presentation as possible. I think in the interest of time, the open house is likely not to be held because I think we will have presentation, there'll be probably a few Q&A opportunities, and that will probably exhaust our time here tonight. One other thing for the record, the commission adopted a success statement, also ground rules. Part of that ground rules related to professional contact and non-disparaging non-disparaging comments. There were a couple tonight that got close to the edge. And so I'm going to ask, as we go through this process, whether it's staff, consultants, commissioners, other members of the public, or whomever, you can disagree respectfully, you can disagree strongly. You just can't disagree personally. Okay?
Thank you for that reminder, and happy birthday, everybody. 10 minutes.
Okay.
Let's go. That didn't work.
Everybody needs to sit down.
There, that might work. Thank you, Mike. Oh, thank you, Commissioner Luxembourg.
That's okay.
All right, we're going to reconvene the Planning Commission meeting. Thank you very much. Go ahead.
Chair, Commissioners, my name is Evan Maxim. I'm one of the planners for the city. I'm going to skip the logistical items that I had on our agenda for tonight. I think they're fairly self-explanatory. They were in your cover memo. And I'll introduce our first speaker from AMEC tonight, Todd Wentworth.
Hi, so yes, my name's Todd Wentworth, and I'm with AMEC Environment and Infrastructure. And I'll introduce us. I'll speak first about the landslide hazard areas, and then I'll hand it over to Brian Taylor, a civil engineer with AMEC.
Can you
who will
get a
talk
little
about the
closer to the
erosion hazard
microphone,
areas.
please?
Debbie, crank it up just a little bit, please.
Yeah.
Okay, so I'll speak first about the landslide hazard areas, and then Brian Taylor, a civil engineer with AMEC, will talk about the erosion hazard areas. So first, a quick summary of what AMEC's role here is. The city hired us to review the recent best available science, to look for science or new case law or professional practices that might indicate that the existing code should be updated. We also reviewed other jurisdictions' codes. So, and then we considered questions the city directed to us and topics that they knew of were concerned, so we could address those as well. But we're here just to provide advice based on science and other standard practices. We're not developing policy or writing the code ourselves. That would be up to the city. Okay, so landslide hazard areas. First, what are they? Subject to risk of mass movement due to a combination of many factors. I'll restate those as, soil and rock type, steepness of the slope, whether you have groundwater seepage coming out of that slope. Those are all the factors to consider. The code, as it's written right now, defines landslide hazards, I think, pretty well, pretty consistent with what is seen. The most common landslides are typical, the shallow failures on steep slopes, at least here in Sammamish. Those are the two diagrams on the left-hand side of the slide. Although if you have the right combination of geologic structures and groundwater, you can actually have landslides on very flat slopes, as is shown on the lower right-hand diagram. This is a map of the city's landslide hazard areas. Both shades of purple represent landslide hazard areas. And this kind of leads into a little bit of the new science that we pointed out in the memo we wrote. The map has been updated recently based on a new technique called LIDAR, light imaging data and radar. I think I got that messed up a little bit. But it really allows high resolution elevation maps. The gray figure is strictly a LIDAR map. And then information from that site can be used with the city's GIS to create these shaded areas, which was shown on the landslide hazard area map. Another real interesting science that's being used in the last 4 years or so is predicting landslides based on rainfall. Seattle's been doing this a lot. And so there's kind of two factors they look at. One is rainfall over a sustained period of time, which this graph shows. You can see if you have more than 5 inches of rain over the 15-day period, you're likely to have landslides. And then the other possibility is if you have very intense amount of rain in a short period of time. And this graph's a little harder to read, but you would be, if you had like 2.5 inches of rain in one day, then you're going to be above that curve and have likely to have a landslide. Okay, moving into the more of the environmental critical area regulations. This kind of defines landslide hazards. In this case, it's just a steep slope. We've got the landslide hazard area that is pretty much protected. And then there are buffers that need to be applied on all sides of the landslide. So Sammamish's code is pretty much like everybody else's, where there's a standard buffer of 50 feet. And really what that means is if the development you want to do is more than 50 feet away from a landslide hazard area, you're fine. You don't really have to do any kind of special studies and be concerned with it. And neither does the city. And this is because science really hasn't found that landslides tend to occur more than 50 feet behind the top of the slope. But some landslide areas don't need that large a buffer area. And so the city's code says, as most do, that if you want to do site-specific critical area studies, you may be able to reduce that buffer, and then that recommendation would come through that study. And it could be reduced all the way down to a minimum of 15 feet. So here's a part of the codes that talk about doing a critical area study, and it gives some guidelines for what that study involves, including site-specific studies. The second code here I've got written down. Now we're getting into kind of recommendations of changes or updates to the code that we're recommending. It allows for a waiver of doing a critical area study if there's other studies nearby. My concern is it could be difficult for the city and the applicant to decide what is sufficient information, what does in the area mean. And also as a geotechnical engineer, I just know that most slide areas or landslide hazard areas are unique, and certainly each development and site is usually unique. So I feel it's important to do a critical areas study with some site-specific information. Now, given that, though, I think the way the requirements for a critical areas study are written, it allows for a scope of work to be adjusted based on the specific conditions. So, for instance, if there really was a site that's been surrounded by very detailed studies, this new site should still do a study, but the scope of that study could be quite limited. It could be an expert going out and visiting the site and reviewing all that other information. So the next step in that would be, I think the city should have an option to have an independent third-party review done on the study. Many cities do this, and I think it works out good. You don't have to do it every time. It kind of depends on the situation. But it allows verification that an adequate scope of work's been done, assures that the study's using current engineering practice, and in case the city staff doesn't have the experts to really review the critical area study report, it offers an opportunity to have an expert do that review. Another part of the code that I think could use some updating is this section here gives some specific requirements for a drainage design when you're near a landslide hazard area. My concern would be infiltrating stormwater directly above a slope could actually decrease the stability of that slope. So I don't think the critical areas regulations is the place to encourage that kind of activity. I think infiltration and having stormwater design is a great thing, and it should be in the city's stormwater design manual, but it needs to be done it shouldn't be done too close to slopes. Okay, so we've been talking about slopes, and I just mentioned whether that would destabilize a slope. The current code does say that a critical area study should address and estimate the stability of the slope of the landslide area. But it doesn't really come out and say what is a stable slope or how would you define a stable slope, and that's what I think could be added to the code. Slope stability is usually defined by engineers by a factor of safety. You don't have to understand this whole diagram. The main thing to realize is factor of safety is a ratio between the forces trying to cause a landslide versus the forces that are trying to resist the landslide. So if your factor of safety is 1.0, you're on a verge of a landslide. Anything could trigger it. So you want to be higher than 1.0 to provide some level of comfort and safety. 1.5 is commonly used in other practices such as WashDOT. That's the state DOT, Department of Transportation. So this little diagram gets to kind of what I mean by that. I mentioned earlier that the standard buffer is 50 feet, but a study could show that it could be reduced. One way to do that is if you've done slope stability and demonstrated that you can maintain a factor of safety of 1.5 based on some other buffer, and all the development would be behind that buffer, then your development maintains a factor of safety of 1.5 of that slope. So I just wanted to go into a little example here of a slope, and this was actually a slope we modeled for City of Seattle. It kind of shows you slope stability, but it also really addresses on my next point to define a slope. The definition of a steep slope or a landslide hazard area, I think, should be defined even more precisely in the code because it says the top of the slope is a distinct topographic break. But that's not defined. And I've seen situations occur where there's a discrepancy of what a distinct topographic break means. You can see on this diagram that this is overall quite a large slope, but there's this bench right here in the middle. And the question would be, is that a distinct topographic break? And is this two slopes or one slope? In this diagram, the red line shows how we're checking this risk of a landslide in the upper slope. And then we also did another analysis where we checked the stability of the lower slope. And that's all good, prudent engineering, but it's also important to check the stability of the overall slope. Sorry, the scale changed on that a little bit, but I think you can see it's the same slope, just a different scale. So that's what another thing I think we need to change in the code is make sure we come up with some definition for how you find the top of the slope and how you define the toe of the slope. There's probably several ways we could do it. I'm proposing this as one option. The blue triangle in the middle of the slope here is already in your code. Your code says that you're in a landslide hazard area if the slope rises more than 10 feet over a horizontal distance of 25 feet. So trying to use that same type of equation, if you will, I'm suggesting, well, what if the slope's, half as steep as that, 20%? So we could define a distinct topographic break as where above that point, or below if you're talking about the toe, but in this diagram showing it at the top. So above that point, the slope rises less than 5 feet over a distance of 25 feet. Some sort of definition like that I think should be added to the code. Okay, so then just to kind of recap my recommendations here. I don't think you need the exemption of a critical areas study for having studies nearby. I think it could be addressed more by a scope of work understanding. Recommend the city have the option for third-party review of critical area studies. Deleting specific drainage requirements from the critical areas regulations. Those could be more in a stormwater design manual. Defining slope stability by using a factor of safety value. And then defining what a distinct topographic break in slope is. So with that, we can move on to the erosion hazard areas.
Just real quickly, do we have any questions from the commission? I have a question, and I'd like this to be addressed as part of the recommendations that we review next time we meet. And that is, I'd like to better understand why you chose the measurement of 1.5 for that safety measurement, as opposed to another figure.
Did you say you wanted me to address that?
No, I don't need that addressed now, but I would like to have that as part of our recommendation packet for next time we meet.
Okay, sure thing.
Thank you.
Okay, commissioners. I'm Brian Taylor. I'm a stormwater engineer with AMAC, and I'm presenting to you today information about erosion hazard areas and the erosion hazards near sensitive water bodies overlay. Some definitions so that we're all on the same page. Erosion is the removal of soil by wind, water, ice, or gravity. Sedimentation is when those soil particles settle out somewhere. An erosion hazard area is areas that are likely to become unstable when disturbed due to the combination of soil characteristics and slopes that make the area susceptible to erosion by water flow. And ESC is a common abbreviation that I've used in the report and in this presentation for erosion and sedimentation control. You also see it as TESC, which is temporary erosion and sediment control during construction. Or if you put a P at the end, that's the plan to mitigate it's the erosion and sedimentation control plan. So there's different flavors of that acronym. So what are the impacts of erosion and sedimentation? We've already heard about some of these. Certainly one of the primary concerns here in the city is the impacts of nutrient loadings in Lake Sammamish from phosphorus and nitrogen. These nutrients can become attached to soil particles, and when erosion happens, the soil is washed from a site downstream somewhere where these nutrients can settle out, which has the potential to change the pH of water or cause algae blooms and oxygen depletion, which is known as eutrophication. It can turn the water green. It can cause fish to die as the oxygen is used up. Sedimentation can also affect the aquatic food chain. It can basically smother the bugs that fish need to eat, for example, and has that effect. It can directly affect fish by clogging their gills and smothering spawning gravels. And it can also clog downstream drainages. You know, water with sediment coming down a steep hill, it flattens out, the water slows down, sediment settles, and you know, certainly at the base of a steep slope, if you have a pipe conveying water under a road, for instance, that can lead to clogging of that pipe or other infrastructure. So typically, these kind of impacts are mitigated or managed through different steps. The most common ways of managing these kind of impacts is to require development to employ a temporary erosion and sedimentation control plan, which we've all kind of seen these in operation: silt fences, settling ponds, mulching slopes, taking measures to keep soil in place, to keep it from getting entrained in the water when it rains. Of course, nothing really works perfectly, so you typically get some sediment that does end up in the runoff, and you have additional measures that are designed to settle that out, or otherwise, or use a different mechanism, filtration, electrocoagulation, some other mechanism to remove that sediment from the water. There are different performance standards for this. Ecology often is shooting for an 80% removal of suspended solids in construction stormwater runoff. Other ways of managing these sort of impacts is restrictions on developable land, seasonal restrictions on clearing and grading, which is basically limiting the amount of work or the amount of areas that are exposed during the wet season. Controlling stormwater discharge so that you're not releasing water at a rate that would cause erosion or creating gullies, so to speak. And vegetation management, because plants and vegetation help to lock the soil into place with their root structures. They also have, you know, canopy that reduces the energy of raindrops hitting the soil. So the conditions in Sammamish that are sort of unique, that are not the same as other places around here. The main one is Lake Sammamish. You know, Lake Sammamish is a big lake, home to many fish, has a whole range of activities that the lake is used for. It's heavily developed along the shoreline, and it does have water quality issues. It's still relatively clean, but there have been numerous studies from the early 70s until very recently that show that the lake is sensitive to increased nutrient inputs. Phosphorus, when it gets into the lake, it's sort of beyond the scope of this to talk about all that, but it just cycles. It doesn't leave easily. It can settle into sediments and come back next year. Other unique conditions are East Lake Sammamish Parkway, which has a lot of culverts underneath of it. That's an area that's particularly susceptible to sedimentation that would clog the conveyances. And historically, a lot of the streams and ravines kind of coming up from the lake onto the plateau are formed by seeps and springs. And it's not like a stream that starts at the top and goes the whole way to the bottom. It kind of emerges partway down. And so adding water to that can increase the amount of erosion if the soils are already susceptible to it, to being moved easily. So the code defines erosion hazard areas as areas in the city underlain by soils that are subject to severe erosion when disturbed. It doesn't apply to all soils. It's those that have been categorized by the Soil Conservation Service or King County Soil Survey as having a severe or very severe erosion hazard. I didn't put the list in here, but essentially there's a map of the entire county, and soils are identified and categorized, and there's a description and a lot of different properties described for these soils. And one of them is, you know, the degree of erodibility for that soil. And the erosion hazard area is also defined as occurring on slopes 15% or steeper. The erosion hazard near sensitive water bodies is intended to provide a means to designate sloped areas posing erosion hazards that drain directly to lakes or streams of high resource value that are particularly sensitive to the impacts of increasing erosion and resulting sediment loads from development. So this is the map of the erosion hazard areas that's been in use here. And I realize it's hard to see at this scale, but I'm sure you've seen it before, and there's a copy over there. Essentially, what we're looking at is the areas on this figure that are shaded green. You can see that there are many along the western bluff and some other areas sort of dispersed throughout the city. The erosion hazard near sensitive water bodies overlay on this map is shaded purple or lilac. And it is primarily these slopes that are proximate to Lake Sammamish, where you're transitioning from the plateau down to the shoreline. So the code right now has requirements for different sets of requirements for each of these types of hazards. The erosion hazard area requirements I've summarized here. It's basically preparation of TESC plans when development happens, maximizing the amount of vegetation that's retained, monitoring discharges if the city decides that's warranted for a particular project, seasonal restrictions on clearing, grading, and filling, which is to say that it's not allowed from October through April 30th. Although there are exceptions that could be authorized if a project is fully mitigating the potential impacts. And the use of hazardous substances, pesticides, and fertilizers may be prohibited in these areas. Again, because if these things become attached to soil particles and the soil is highly erosive, there's a much greater chance of these materials being washed downstream. So one of the things we looked at in the report and in our evaluation was the seasonal restriction. We found that the dates were fairly consistent with what other agencies in the state is using. It's generally recognized as the time of year that we need to be more sensitive to the development activities. Some agencies allow exposed soils for a couple days during the wet season for work to occur. Other agencies don't. The higher standard in the city is justified by Lake Sammamish sensitivity to phosphorus inputs. That's what brought the code into being. The code also says that exceptions may be authorized if fully mitigated, but that isn't defined in the code. So one of our recommendations is that the measures that constitute a fully mitigated project be further defined so that applicants who want to do work in the wet season have an idea of what would be expected to get that exemption. And so we've identified criteria that other places have used that would increase the level of control to prevent erosion from these erodible soils. And these would include frequent inspections before storms. Daily is about as frequent as you can get. Establishing erosion control leads for projects. This is a strategy that for projects that need to get an NPDES permit, they would have to do that. Of course, the code speaks to projects smaller than the 1 acre that would trigger that kind of permitting. Water quality monitoring, basically measuring what comes off the site to see how well the control measures are working. A contingency plan, that's basically requiring developers to have materials, staff, like the phone tree, things that you can implement if things are going sideways on the site, the measures aren't working, so you can quickly correct it to prevent and mitigate any damage that might have happened. A seasonal suspension plan, if it's a particularly wet year, if it's clear that the measures just aren't working at a site, to have a plan to button up the site, to get it under control, to wait out the wet weather. Infiltrating water or conveying discharges past an erosion hazard would reduce the risk from that kind of development, so that is in the list. Financial guarantees in case the developer is unable to get things under control if things are going sideways at the site. A grading stabilization and restoration plan, basically saying this is how things will be restored so that when the construction's over, it's not going to unravel, so to speak. And a vegetation management plan, which is along the same lines to, once an area's been disturbed, to ensure that plants get established because of the structural benefits of having vegetation on a slope area of soil. So in terms of the other requirements for the erosion hazard areas, the vegetation retention, we didn't, the best available science, everything we've seen supports that vegetation is a good practice to keep soil in place, so we don't recommend any changes on that. The option for the city to monitor discharges, we recommend requiring a contingency plan of actions to take if that monitoring indicates that water quality standards are exceeded. In other words, monitoring gets you so far you can identify if there is a problem, but making sure there's a plan in place of how you would fix a problem if you find one would be prudent. And the requirement that hazardous substances, pesticides, and fertilizers not be used in these zones, there's nothing to suggest that that is not warranted. So getting to the overlay, the erosion hazard near sensitive water body overlay, it establishes a no disturbance area with some limited exceptions. And it also establishes sort of a sequence and prioritization of drainage design requirements, infiltration being the first choice to manage water. By not releasing it on the slope and putting it into the ground, you've reduced the hazard of discharges from a project, destabilizing these erodible soils. The open space requirement, which is to say that if you cannot achieve a high level of infiltration, you're requiring the site to leave part of it undeveloped so that you're going to be creating less surface water to begin with. More of the rainwater will soak into the ground, which reduces the risk of water going over the erodible areas. An imperviousness limit basically also kicks in if the peak discharges from the site cannot be fully infiltrated. Again, with the idea to control the amount of water that's being yielded from a site into erodible soils. And having outlets, drainage outlets from sites when water cannot be fully infiltrated that are designed according to best available science. So part of what the code speaks to is how the erosion hazard near sensitive water body overlay is delineated. The code now reads that the upland boundary is at the first obvious break and slope from the upland plateau onto the steep valley walls. This is a similar issue to what Todd was speaking of, that having a little bit more clear criteria would be helpful. Right now, the city is maintaining maps of the approximate location, and these are verified in the field for each individual parcel. We recommended changing this language to be consistent with the definition of erosion hazard areas that's already in the code, which is related to a 15% slope. And so our language says the upland boundary would be at the first time slopes exceed 15% from the upland plateau onto the bluff or other downgradient area. We support the same recommendation as with the landslide hazard areas, that using LiDAR data, because it's a more accurate topographic mapping method, that could improve the accuracy of the city maps. And that would probably result in changing the extents of the overlay from what it is today. And we think that it should be clarified who is qualified to conduct a field verification of the boundary of the overlay. The development restrictions for the no disturbance area, there are accepted activities to that, which are individual family homes, access drives, utility easements, and public parks. For these types of projects to get the exception, they're required to prepare a report showing that there would be no impact, and to provide mitigation, monitoring, and bonding, and to minimize the duration of clearing for the site. So we're not recommending any change in that requirement. We did not find any science that supports that you could impact these erodible soils more. And so we've not recommended allowing additional development in these areas. The second element of the overlay applies to sites that, using the language of the code today, historically drained to the no disturbance area. This requirement applies to new subdivisions, short subdivisions, institutions, commercial and binding site plans. It requires those types of projects to retain runoff on site, which basically means infiltrating, or I guess if you were doing rainwater harvesting to use that water somehow, that would probably qualify as well. There is an exception if that requirement prevents you from achieving 75% of the maximum density. An additional requirement is that if it's not feasible technically to infiltrate your 100-year peak flow, this is where those other requirements I mentioned kick in. You must set aside 25% as open space, limit your total imperviousness, and provide a drainage outlet designed by the best available science. So we have two changes we're recommending here. One of them is just kind of to clarify the way the language reads, that it was sort of historically areas that drain to this no disturbance area. It makes more sense to address sites that drain to the no disturbance zone now. And secondly, we believe that an outlet design per best available science is something that we know what that is, and that should be more clearly defined so that applicants know what's being asked of them. Basically, what that would be a continuous pipe to take water completely down the slope, protecting the erodible soils in the process and take it downstream of where the impacts this code is trying to prevent could be prevented. And then the second element, I did not put it on the slide, but would be to release water at a rate consistent with pre-developed flows, so you're not increasing flow rates in stream channels that have never seen that much water before. This is my last slide. Within the overlay, there's a separate set of requirements for single-family homes. And basically, single-family developments, improvements to existing structures within the overlay that result in a site with more than 2,000 square feet of imperviousness must prepare a drainage design, and that design must seek to infiltrate as much of the water as technically possible. And if it can't infiltrate all the site runoff, the second preference would be to infiltrate the runoff from the impervious surfaces. If an outlet is needed because not all the water can be infiltrated, it should be designed using the BAS techniques I just discussed. And there's an exemption for projects that don't add more than 200 square feet to residences that were constructed prior to 2006. And we are not recommending any changes to these requirements. That concludes my presentation.
Thank you. Do we have any questions from the commission?
The obvious one is, it doesn't really address any cumulative effects in how residences that are stacked one upon another, you get quite a bit more water coming through, and you're only making a requirement to take it to the next flat area. In reality, you're going to need to take that water to where it's the next safe area, because it might not remain flat all that long.
So you're suggesting we consider an alternative to the recommendation?
I'd like to see what the cumulative impacts are. You haven't really addressed that.
Does staff understand the request? Yes? Okay, great. Anyone else? I'd like to better understand how the erosion areas and the landslide areas overlap in the city, and how the infiltration requirements on some may contradict the desire to not have infiltration in a landslide area. Yes, Commissioner Collins.
So saying it a different way is that infiltration is the number one factor that we're looking at here, is that really best available science? Or should we look at other uses for that water?
Well, I think that there's been a lot of, kind of the wave right now, statewide and nationally, frankly, is for low-impact development, which is a set of strategies that are really emphasizing reducing your volumes of runoff that come off a site. And generally, within low-impact development, infiltration is advocated as your best strategy to use. But that doesn't take into account potential issues with steep slopes and slope failures. So I think that part of the distinction that should be noted is the steep slopes that Todd was speaking to and in the landslide hazard areas are quite a bit more than the 15% that we're talking for these areas. So there's probably room for additional study to see where the break point is on slope that would make infiltration less attractive because of the potential to destabilize slopes. But the difference between the 40% slope of the steep slope areas and the 15, there's quite a range in there, so.
Okay, so I think we would like to understand that better. Commissioner Luxembourg and then Commissioner Coleman.
Not tonight, but I'd like you to include some additional information about the new technologies and how they can be used or how they can't be used to achieve no impact.
Yes, I would just point out that I had substantially more discussion in the report than I presented here tonight, so.
Understand.
Yes.
I'm a little confused in the report why there's a discussion about erosion and sedimentation control practices, and those are assumed to be used to address erosion kind of in normal development conditions, but it doesn't seem that those same practices can then be applied to the sensitive water body overlay, where we've got the erosion hazard sensitive water body overlay. You following me? So it seems like we can apply those practices outside the overlay, but we can't within the overlay. And
You want to understand why the practices are acceptable outside the overlay but not within?
yeah, it seems like the only answer is don't apply them within the overlay, just don't touch the dirt. I'd like to understand that a little better.
Well,
you don't have to respond right now. I'd like to have you guys look into that a little bit.
All right.
Thank you.
And I think related to that, I anticipate one of the recommendations that we will receive is going to be based on the public input that we've received so far, and that recommendation will be to assess whether or not to retain the overlay/no disturbance. I think within that, we need to understand better how do we still, what protective measures could we consider employing as an alternative to the no disturbance. I think we need to explore that further. I think saying that keeping it is the safest thing to do is understandable, but we'd like to also understand if we don't keep it, what are all our alternatives and what's the risk that we might be taking on as a city.
Okay.
Commissioner Islam and then Commissioner Wasserman.
On page 2 and 3 of your erosion hazard areas and erosion hazard near sensitive water bodies report, you cited 2 examples. City of Seattle has 18 required elements and King County has 8 or 9. Then I didn't see any recommendation from those examples with respect to City of Sammamish. I was wondering what made you not to make any recommendation yet you had added those elements for our thinking.
Well, you're right. I have shown a lot of how erosion control practices have, I guess, evolved. Some of the other speakers have some of the other public comments have, mentioned how erosion control regulations have progressed over time, and the technologies have gotten better, and that's totally true. And in the report, I felt like it was important to show that. The thing is that there is always an element of risk because nothing works 100%. And
Frankly, the challenge with stormwater and erosion control is that, many times when you really need things to work, you're having the biggest storm ever is when the power goes out and things go sideways. So it's, the task that is before you, I think, is balancing the risk with the technologies that are out there and figuring out the level that is acceptable.
So is it fair to say, even though you gave examples from 2 jurisdictions, you didn't feel it would be your scientific authority and position to recommend anything without being able to quantify the risks?
That's correct.
Thank you. Commissioner Wasserman.
I guess I have a question. Maybe I'm a little confused by between the two of you, what you said. I get the impression from listening to you that you're talking about taking water down along your line and just tight lining it down to the bottom of the hill or whatever the case. Now, that being said, now you go back to start looking at all the phosphorus that you're dumping down off the road in a tight line. How do you save one without shooting the other? I guess that's something I'd like to know down the road also. It doesn't sound like you guys are talking out of the same side.
Well, I'm not sure I see the inconsistency, but...
Maybe I'm just not saying it right. I mean, I understand that there's a concern about phosphorus coming down the hill in runoff into the lake, right? But if I'm tight lining stormwater, I'm basically just giving a clear access all the way down to the lake without any buffers or anything like that between it, right?
Right. Well, a stormwater discharge would have to meet, all of the stormwater discharge requirements, frankly. So
Put that
new
on
developments.
individual residents, right? That goes on individual residents. And then if you have a situation where you're 2, 3, 4 up the hill, I guess that's my concern, is the guy at the bottom ends up eating the cost.
Well, it's something we can look into more. The tight lining requirement is specifically addressing the fact that if you have a discharge that's kind of eroding a slope, that's a continuous source of those nutrients that are attached to the soil particles and kind of coming from the soil itself. Once a site's been built and is stabilized and it's not in an erosive state, you wouldn't expect to have the same level of nutrients coming out of the site to begin with. So if you have phosphorus control BMPs applied to a site that are taking out the phosphorus, everything's stable, it's vegetated or paved basically once it's developed. You don't have exposed soils being washed away that are bringing the nutrients with them. At that point, the objective changes from, at that point the objective is, you have a discharge, it's not a burden of phosphorus that you just want to get down the slope without creating an additional problem.
So the problem that we're not trying to solve in this discussion is water in the lake. The problem that we're trying to solve is what the water is carrying with it into the lake. Is that correct?
Correct, because studies of Lake Sammamish have shown that they've shown a couple things. I mean, one of them, it has, as other commenters have spoken to, it has shown that once the sewage was diverted, one of the major sources was stormwater runoff. But it's also been pegged that, a major source when the Lake Sammamish management plan was done in 1996, I was on the team that did that. I actually put together the water quality model of loading of phosphorus to the lake back in the day. And one of the things that was really interesting to me at the time was that the soils around Lake Sammamish have naturally high levels of phosphorus. And so during the construction process, and if you think back to 1996 too, there was a lot of construction going on in Issaquah up on the plateau. And so at that time, it was recognized that tightening up on the construction phase would do a lot to reduce the total phosphorus inputs to the lake. Once a site's been built and it's stabilized, your sources of the phosphorus then change. It's more from what are the activities going on. When I spoke about the lake management areas, I spoke about some of those sources of phosphorus. But this overlay is really geared to the construction phase, is my understanding, and what it primarily is addressing.
I got one more follow-up question.
Okay, Commissioner Wasserman.
You just lost me on that one. Didn't you just shoot down the definition of a buffer if I've already got a pre-developed site?
So okay. In these particular areas, the buffer is related to the landslide not the erosion.
Well, all right, I'm not talking about erosion now, I'm talking about the phosphorus. When he's saying that once the site is built out, the phosphorus level stops, basically. So all of a sudden, I'm back to looking at buffers for other properties where there's been no development and no construction, and we're trying to develop buffers of 50 or 100 feet to stop phosphorus from going from one place to another. That I'm understanding you saying right now that doesn't happen after the site's built. Did I miss something?
So there's no buffer for erosion.
Well, I'm not talking about erosion, I'm talking about phosphorus now. He just said.
But erosion is the source of the phosphorus.
I understand that.
Okay.
But my question is, and maybe I'm just misunderstanding
Yeah,
what
we're
he
not
said.
understanding your question.
All right. If I just understood him correctly, the phosphorus stops once the construction process has ended. All right, if that's not what I just misunderstood him
It
say.
stabilizes.
It's stabilized. Okay. That being said, why am I worried about buffers on regular property where I might have phosphorus? I'm just not making the correlation between the two.
A development project has to put in stormwater treatment facilities as part of the stormwater code, and those facilities are going to be designed to remove phosphorus. So it's not that the phosphorus totally stops. It's coming from different sources. You know, for a developed site, it's coming from things like fertilizer applied to the lawn, different chemicals that somebody might use on their site, atmospheric deposition. But it's not coming from kind of ripping the ground open and exposing all this soil that has this phosphorus to come out of it. So you have a different set of practices during construction to take care of that source. And then once it's built, you have your stormwater treatment facilities, and you also have stormwater detention facilities, but the treatment facilities are what is your primary control at that time. So the stormwater codes are written, you know, when you drain to a sensitive lake, that you have to put in an extra measure of treatment to hit that phosphorus reduction standard, and that's what's in effect already.
So are you asking, does the code have buffers to prevent phosphorus? Is that the question?
Well, I guess that's my question, because it sounds like where we've been before is we're looking at however distance of buffer widths because we're concerned about phosphorus. You're telling us the biggest concern is, and maybe I'm just talking about two different things at the wrong time, but I'm just not seeing a correlation. I guess maybe that will come down the road.
Pardon me for stealing the mic from Mr. Taylor here, who's doing a very good job answering the questions. I do want to just be clear, our buffers aren't intended for phosphorus removal.
All right, I thought that's what I had heard someplace
Yeah,
previously.
no, and I apologize for just jumping on that. I would think it's fair to characterize the overlay primarily as focusing on essentially regulations around the developing condition rather than the developed condition. And that's probably a distinction we want to keep in mind. I think it's one Mr. Taylor was speaking to a moment ago. The erosion sediment control is something that we use when you're developing a property, when it's open. The dirt is exposed to the elements. It's also true that when we're talking about a tight line, that tight line will be connected to a stormwater pond, which I think Mr. Taylor would agree is designed in of itself to remove phosphorus from water that might be tight lined down to the lake. But it's just not an accurate statement that we're using buffers themselves for phosphorus.
Do we have other questions?
One more.
Commissioner Luxembourg?
I wanted to follow up on the, excuse me, I wanted to follow up on the risk analysis. You were talking about, you know, sometimes you have the storm of the century and things go sideways and you have to balance the risk. I think that's a really important idea. In the follow-on materials, not tonight, help us understand what that means or what the mechanisms might be for balancing the risk.
And I have also one other request, and it's related to the definition of fully mitigated that you've included in your recommendation or the requirements. And this is a request to some degree for staff. I'd like to understand how the recommendation compares to our current practices, even though those are not necessarily enumerated in the code today.
Okay.
Okay, thank you. I think that's all our questions for tonight. Seeing that it is now 8:50, I would like to recommend that we not have a formal open house tonight. Does anyone on the commission have a recommendation to the
Will it
contrary?
be postponed or canceled?
I think we need to have some offline discussion about whether or not we have an opportunity to reschedule it. And I'd like to certainly have some input from the commission about whether or not that is something you would like us to consider. Okay? Okay. Anything else? I have a few closing comments. Would you like to go first?
Very briefly, this is step one of two steps. Your next step would be to consider some specific recommendations, take additional public comment, and then give staff direction on advancing items into the process. That will take place on June 28th. We'll also hope to have more material related to the general risk analysis format and how that might work that night. And I will talk with the chair about how we can, if we need to accommodate, and how we can best accommodate the missing open house that we didn't get to here tonight.
Thank you. So 2 other quick comments. One is part of the packet materials that we did not review tonight were some recommendations for administrative changes to the code. I want to kind of share with everyone that our intent with those is to proceed those recommendations for further consideration without discussion as a commission, unless specifically you request one of those items be discussed at our next meeting. So we're going to handle it kind of like a consent item, that unless a commissioner would like us to formally discuss one of those administrative recommendations, they will just proceed automatically to the next step of the process. So I would encourage all of you to read through those with that in mind. And we will definitely discuss anything that any commissioner would like to discuss, but I want to make sure that that's clear, that we're going to focus our discussion at the next meeting on the recommendations around the 3 topic areas that we covered tonight. I also want to just share that we had a brief discussion about request for some opportunity for citizens to meet directly with staff and perhaps flesh out some of the alternatives or recommendations that you would like us to consider more formally, and we will have a follow-on conversation with staff about how we might create an opportunity for that to happen. So I just want to acknowledge that. I think that's all I have for tonight. Does anyone else have anything they'd like to say? With that, we will adjourn at 8:55. Thank you very much.
Thank you.